have been adequate. They have been, in my mind, full-throated. They have been accurate. They have been as detailed as I could make them. Now, whether or not you wish to move to disqualify me, that is your choice, but the time period has frankly passed. Motion to disqualify me at this point, based on the disclosures that I've made, would be untimely. And so, what that means, sir, is that I'm going to stay on this case, which means over the course of the next few days and weeks, I'm going to review the great number of motions that you have filed, and I'm going to begin setting those for hearings. So stay close to your email, because you'll be receiving emails that will be having, there will be to you, either to Mr. Mansfield. Mr. Mansfield, are you directly prosecuting this case? Are you the lead prosecutor?
Yes, sir.
Okay.
Yes.
My judicial assistant, I will instruct her. She will, upon me reviewing these motions and trying to determine how much time is needed, if it's something short that maybe I have a question about before we set it, we'll set it for a short hearing. But it is more likely that these motions, based on my very brief review, are a little bit more substantive in nature. They're going to require us to take some time. Mr. Tucker, I'm aware that you've been appearing via Zoom, that you may wish to travel in order to litigate these motions, meaning you may wish to be here in Marathon, Florida for open court. Again, you may wish to be, and I may order that you be here, depending upon the nature of the motions. You have to understand, sir, up until now, I have purposefully not made any rulings in any portion of your case, because I wanted to get past this issue of either my recusal or your request or motion to disqualify. It seems as though we are past that. Now action will begin from my perspective on your case. You understand that? Yeah, it would make sense for us to basically carve out an entire day where Mr. Mansfield can plan a trip up here and be here, you do your trip here, and we all be in person. We take one full day to litigate the matters, and then we can have resolution perhaps on some or all of them. Okay, so just again, like I said, I'm staying on the case. I do not believe, based on all of the research that I've done, that I'm required to recuse myself. I have clearly said that I believe it is my duty to make those disclosures. I've made them as clear as I can. And so stand by, be checking your email, because over the course of the next 2 weeks or so, you will be receiving communications from my judicial assistant indicating to you.
All right, everybody. So I do apologize for the introduction there. I had my mic. I had my mic muted, so I apologize. Anyways, we are watching the Tucker case. This is the hearing that happened today. Now, unfortunately, Mr. Tucker is recording this, screen recording this on his computer, and it doesn't record his end. So we are going to have to kind of guess what he's saying, and by what the judge says in response. So, anyways, let's continue listening the best we can. Like I said, unfortunately, he is muted, so we will have to, or it's not that he's muted, it's just not picking up what he's saying. So that's why you're hearing that as he's talking, it's not saying anything. But as I was saying, if you were here during the ill-fated attempt to enter into the show, we're going to be watching this hearing. We're going to be going over a response he prepared today and filed on his motion in limine, which I think has some very, very good information for everyone who's interested in his case. And then we're going to be going over when the trial date is, when the new trial date has been set. So anyways, with that said, let's get back to listening to this hearing. So if you're good at lip reading, I have no idea what he's saying. We're going to just kind of zoom through this.
I believe his email is in Judge,
All right, here we go. Let's listen to Mansfield. He's going to be.
Judge, the motions I filed were all electronically filed. I believe his email is assigned to this case, so I don't know why emails would not have gone out to him when we electronically file things. The attorney of record for the opposing side is emailed, so I don't know. I don't know why he wouldn't have gotten them, but and Judge, there's one motion in particular. I think both sides want transcripts from the trial, and I'm concerned that that's a lengthy process. If Your Honor, I don't think there's going to be any opposition from either party to get those started. So if Your Honor is inclined, we could at least, you could maybe make a ruling from Chambers on that, and we could get that process started, because I think that's going to be a big chunk of time before we can get those in.
Okay. If you recall the last. Well, so for the both of you, if you recall, the first time I called this case, we had talked about 5 or 6 different issues. One of those was these transcripts, and I'd asked Mr. Mansfield if he was aware of any authority or anything at all that said that the clerk of court or the court reporters were required to give a transcript or to make a transcript. You see, I've been told they don't have a transcript. I've been told they have all of the recordings. I've been told they will gladly provide to both of you the same recordings, and that you can use the resources within the state, the state attorney's office, or however you get that done, and that Mr. Tucker can use whatever resources he has to get that done, to create transcripts of the original proceedings. And I'm sympathetic in some ways. I understand that you would want the transcripts, but I'm not so sure the clerk of court is required to make transcripts unless the case is on appeal. And we were either related to request from court admin. Okay. Folks, I know, look, I respect, I understand precisely why you want them. I understand. I have no problem right this moment ordering, both of you to have equal access to obtain copies of all trial proceedings. I have no issues with that. But again, I've only been told that they don't have transcripts. This isn't something that, not like we have transcripts that are sitting on someone's desk waiting and we're just not giving them to anyone. That's a product that would have to be created. And when I learned of that information, I just thought to myself, well, I'm not aware of a rule that requires any transcript to be made of a mistrial. So I just wanted to know if there was some authority or precedent for this. That was all. I haven't been presented that, so you all be thinking about that. I have so much to do. Go ahead, Mr. Mansfield.
No, I was just going to say, and I couldn't find an actual authority that addressed these particular facts. I mean, everything I found was obviously when it's up for a direct appeal. So that's fine. If we get audio, then we will find a way to get them transcribed. I do want to. My assistant just popped in and she wants to confirm defense's email address to make sure that we have the right one. So Mr. Tucker, if you can give us your email address, we can confirm it. TYES? All right. Okay. That's all right. TyesLife747@gmail.com.
You want to address the gag order?
No, I don't have a stop yet. Okay.
Like,
Okay, so interesting little tidbit I just heard there. I don't know if you guys heard it too. It sounded like that was Alvarez off camera saying, "Do you want to address the gag order to Mansfield?" So looks like they're going to try to reinstate this gag order, which is what I was suspicious of. So it's becoming very important, I think, right now. Even more important. I'm going to have to just speed this process up in terms of um, getting my episodes done on this gag order, the original gag order, because it is so important that everybody understand what this gag order means. Because what it means is they're gonna try to silence Ty Tucker. They're not just gonna silence Ty Tucker. They're gonna be trying to essentially seal the file on this case. So anybody that gets interested, anybody that says, "Hey, I want to go check this out. I want to go." I want to go see what this is all about. They're going to seal this case and they're going to seal the order, or they're going to seal the records in this case. And that's concerning because it essentially kills the media coverage on the case, because when the media can't get access to things, they don't stay interested. And it looks like this case is going to drag into the fall, possibly beyond. And what we want eyes on this case. So it's going to be important. Again, you got, like I said, the censorship I'm going through at YouTube, where they're trying to censor the channel where I have the biggest voice right now. I'm hoping to grow on Rumble. I'm hoping to grow on Kick. So if you're over there, guys, hit the follow button, because like I said, I'm being censored right now over there. The good news is it calls me to reach out and find other platforms quicker than I thought. But this is mega important right now that gag order doesn't get put back in place, because that is going to put Ty Tucker at a disadvantage. Anyways, let's continue listening.
747@gmail.
Yeah, that's the email that's in there. So I don't know why. I don't know. I can't answer why you're not getting them, but we'll get them to you.
All right. Well, anyway, this was supposed to be just a short hearing to let you know that work will begin on myself reviewing the motions. Again, the time has expired for the defendant to move to disqualify the court and the sitting judge. So he's not set for any other court dates. So, Mr. Tucker, I'm going to share on my screen the dates that I have coming up for all felony matters. Let's see if that shows up. Okay, you can see there in court, it does show up. And so it should be on your screen now. So here's what I have. So let's recall, here's what we have. We have, pursuant to those rules of criminal procedure, the court was required within a certain time period to conduct a retrial of your case. I asked you several questions about that. You've affirmatively waived any quote unquote speedy trial obligation or rule or constraint. You affirmatively had requested a continuance. You had indicated that you wish to engage in some motion practice. Of course, you both wish to obtain transcripts, and there's still some, but potentially more than I had predicted, litigation that's going to occur between now and the retrial. So we had indicated that it is more likely that this case will be tried in the second half of 2024, but it is my goal And I wanted to let you all know of the date that I have penciled this case in for now, so that you can advise me as to whether or not these dates work. I've just completed my calendar, and I have set aside yes. Yes, yes, sir, but I'm looking at a different calendar right now that I'm not sharing. Um, I wanted to at least gauge your availability for trial in September of 2024. Now, likely trial would occur, between September 9th through the 20th. So that would be a 10-day trial period. And my hope would be to pick the jury the week before at some point. So we would actually meaningfully start trial on Monday, September 9th. I at least wanted you all to know that that's a time period that I had identified. I can move a few things around to do another day. But Mr. Mansfield, if you have any input, looking at your calendar, it's gonna be trial starting sometime that first week of September, but the substantive portion of the trial would begin on September 9th and go through the 20th. Do you have any sense as to whether or not those dates would work for the state?
Judge, they'll work. Is there anything sooner than that the court would be able to accommodate something earlier than September?
Well, maybe. Let's ask Mr. Tucker. Mr. Tucker, if I were to set this case for trial in August, would you be prepared? For trial. Don't you worry about time. Sir, don't you worry about time. I assure you that I will be here just as long as I'm needed for trial. Mr. Mansfield, I could potentially have some availability in August. I do have some dates that I can move around. But I wouldn't say I completely agree with Mr. Tucker, but I will say that there are a number of issues that we need to iron out. Transcripts being the first one, those are gonna take several weeks. Even if you were to get the audio, this week or next, I mean, that's gonna take 3 or 4 weeks at a minimum to get transcripts. That's probably, and that was what, 13, 14 days of trial. Well, Mr. Tucker, I'm here to tell you that absent some extraordinary issue, we will not be trying this case after September, okay? I've proposed what I think is a reasonable amount of time based upon what you relayed to me. My
are we going to rehash the trial at this moment? Judge, are we going to rehash the trial at this moment in time, because there's a lot the state could say on this issue as well, but I didn't think Your Honor wanted to get into this today.
Yeah, for now. Yeah, for now, I'm going to go ahead and set some trial dates. Because that will make sure everyone knows what to expect. We can move the trial up if needed. We can move it sooner if we've resolved all these issues. But for now, I need to move a couple things around. What I would like to do, Mr. Mansfield, how long did Wadir, the first time around, were you able to conduct Wadir and jury selection in 2 days?
3 days, Judge. It took 3 days the first time around. It took 3 days, Judge.
Okay. Well, what I would like to do is, we can start jury selection on Thursday, September 5th. And potentially complete jury selection Thursday and Friday.
Yes, sir.
And,
Judge, I think
go ahead.
no, I'm sorry. That'll work. That's fine with us, Judge. I mean, as far as the pretrial motions, I would ask the court to set up maybe a motion deadline so we can have, a line where everything gets filed before.
And we also have an emergency.
Yes, I'm about to do that. I'm about to do a number of dates right now. This was supposed to be a short hearing where I told you I'm staying on the case in light of the research that I've done. I've only come to that conclusion. And second was to set a bunch of dates. I recognize that, I've left this September date a little soft, but I'm not going to do that. I'm going to set this case for trial in September, on September 5th. September 5th and 6th, that's a Thursday, Friday. That's going to be jury selection. I would like to hope that we can complete jury selection before we leave on Friday, and start fresh on Monday morning with instructions and, basic instructions and opening statements. But if we need to continue on into Monday, I think that would be fine as well. I have blocked off until September 20th. I don't have any hearings. If we need the following week, I think I can get coverage for that following week if we need up to 3.5 weeks. You see, I think that date works good. I want you to put that down, sir, and make sure that you're aware that that's what I'm expecting trial will be. Now, what we're going to do is I'm going to reset and rather put this case on for a pre-trial hearing in May, okay? So the next date I set, and I'm going to go chronologically forward, is oh darn, I have a separate homicide case next month, so we can't do a date I was thinking of. What I'm going to do is I'm going to put this case on for a pre-trial hearing on June 17th at 1:30. Okay, that's going to be June 17th at 1:30. That's going to be for a pre-trial hearing. Between now and then, I should have a handle on all the motions. Again, that's just going to keep track of the case going forward. Again, what I'm going to leave open today is when these various motions are going to be set. I need to read them. I need to assess how much time or what witnesses, at least I believe, will be called. Look for an email from my judicial assistant because she may be asking you all these questions. Please advise, how much time the state needs, how much time the defense needs on this motion, so we can hopefully put everything together.
Judge, trial in Key West or trial in Marathon? I just was curious. Are we going to try it in Key West or try it in Marathon, Judge? I'm just inquiring what your plan is.
I'm trying to work on that right now. I don't have an answer. The plan is for Key West. The plan is for Key West. The plan would be to do all pre-trial litigation here in Marathon, and the trial would occur in Key West.
Okay.
We're just gonna have a much larger jury pool to pick from. And, you know, with extra 10, 15 minutes to address a couple of issues in your case. And I want to do it sooner rather than later. And well, do you have in front of you this meeting ID, the one that is 936-5202? Always going to be the meeting code that starts with 936 and ends in 933 going forward. All right. So, next time we'll see each other for sure will be on June 17th at 1:30, and be looking out for emails from my judicial assistant so that we can begin scheduling some of these hearings.
All right, guys. So that concludes the hearing. Not a lot of fireworks, no rulings on any motions. We didn't expect that. Judge has officially taken on the case. I still don't know if that's a good thing or a bad thing. I don't get the warm and fuzzies necessarily about this judge. I get the idea that he's warning Mr. Tucker, like, hey, don't be upset. Don't get buyer's remorse when you don't like how I conduct your case. I also don't like what he continues to insinuate, where he says, understand, Mr. Tucker, I haven't ruled on any motions. Remember, there's still an outstanding issue out there in regards to a motion and a filing that was filed in relationship to his ankle monitor going off. Now, Mr. Tucker's filed some motions in regards to asking that his pretrial release be modified. So we're going to see that. And then we've also got a motion in the first response from Mr. Tucker that he's filed here in official response on the motion in Limine. Now, the big one's coming, which is the motion to dismiss, and he seems to be insinuating that he doesn't expect that's going to be something he's going to take serious. We'll see how it goes. Again, we'll see how he conducts himself. The first real hearing of us knowing what we have will be that June hearing. Now, I do like the way that he set the trial out, and he's not kowtowing to Mr. Mansfield, and you know, he seems to be being pretty fair. I hope this guy gets into this case, because here's the thing: unless you're motivated in this case to see this case differently, there's no way a honest judge could look at this case and go, wow, this is fair. Wow, there's not a problem here. There's just no way. So we have a trial date. That was supposed to be the final thing, but I figured it might come out in here. September 5th, put it on your calendars. It sounds like that is going to be the date that he will be back. We will be back to court watching this, and you better believe we will be following that. That will be right after my wife gives birth. So I will be going on a small maternity leave coming off that, and that'll be probably the first case I'll cover coming off, because coming off when I take a little break in August for the birth of my fourth child. So we will be looking forward to that. That's going to be something we're not going to miss. If this judge doesn't decide to dismiss, although I don't get the feeling that's where he's going to go. And judging from the case we're covering, the Calvin, oh gosh, the last name's escaping me, but the case we were covering earlier today, where the gentleman who had a police officer on tape planting evidence, clear due process issue, and that judge said, nope, throw it to a jury. I think we're at a time now, this judge is going to find every reason not to dismiss. It's going to say, Mr. Tucker, you can raise all those issues with the jury, and they're going to send it in. And, that's just where it's going to go. And then we'll find out, will Mr. Tucker bring his attorneys in the 11th hour? I don't know. We'll find out. But anyways, next thing we're going to look at here now is the response Mr. Tucker filed today. This is chock full of very interesting information. I'm going to get it pulled up and calibrated here so that we can all see it. And we're going to go through this and break it down. So let me take away the trial date there. So here we are, guys. This is the response. This was filed today. You can find this response on the website of the Monroe County Clerk's Office. I'm also going to try to post this up on my two websites, the Buy Me a Coffee sites and coffee.com site. I'll see if I can get it up on my Patreon site as well, so that you can review this for yourself, read this, dig into it, because it's definitely, I think, worth looking at, worth reviewing. Especially when you get into all the information that it contains. I don't know why this thing's not staying zoomed in. Let's see here. I think I got this under control now. Let me see. Good. We're up there. All right. So here we go. Defendant's response in opposition to plaintiff's state of Florida motion in Limine. So now, look, guys, dig in here. Listen in. I've got it up on the screen. Hopefully you can see it. Read along with me. We're going to talk and we're going to discuss parts of this because there's a lot of good information in here. Some I'm already familiar with. Some I might not even be familiar with. But we're going to get into it here. Comes now pro se defendant Franklin Tyrone Tucker, hereinafter will be referred to as Tucker, files this response in opposition to the state's motion in Limine, as their stated causes are neither factual, nor does the state attorney give a sufficient legal argument to warrant granting such an order. The defense would argue that the court made significant errors at trial, including not allowing the defense to inquire about the investigation, the tampering with evidence, or the misconduct committed by the state attorney Dennis Ward, hereinafter Ward, members of the state attorney's office, members of the Monroe County Sheriff's Office, hereinafter MCSO, Rick Ramsey, hereinafter Ramsey, and even Honorable Judge Mark H. Jones, hereinafter Jones. Throughout the entirety of this case, furthermore, Mr. Ward has yet to even reconcile the gross misconduct committed by his assistants at trial. Those actions were more than enough to warrant ASA Joseph Mansfield, hereinafter Mansfield, ASA David Alvarez, hereinafter Alvarez, and Mr. Ward all to be disbarred from the practice of law. Big statement there, but I would agree with Mr. Tucker here. Instead, he expects this court and the defendant to ignore what happened and the damages they caused to not just to Mr. Tucker, but to the integrity of the entire 16th Judicial Circuit. He has the audacity to think he can just rush this case back to trial, foregoing any sanctions or relief the court would deem necessary to ensure this behavior is not recurrent. The fact that he would do so by further insulting the integrity of this court with a motion that states he knows to be false, that states causes he knows to be false, should, in and of itself, be enough for the court to consider using its discretion, foregoing the defense's upcoming motion to dismiss, and immediately vacate the charges against the defendant. That by continuing to be deceitful in his deeds and untruthful in his statements to the court, Mr. Ward has already displayed enough bad faith in this prosecution to warrant such an extreme measure. While this is the defense position on the matter, if the court is unwilling to take such actions, the defense would only request that the court offer some sanctions or relief as it deems appropriate to prevent further damages to the defendant and to the entire framework for the justice system of Monroe County. In addressing these issues, the defense would first like to offer individual rebuttals to Mr. Ward's causes, establishing such bad faith, and then conclude with additional facts that would support this court without motion, dismissing the charges against the defendant with prejudice. That issuing such an order would be in the best interest of justice for the defendant, for the county, and for preserving the integrity of this court. Rebuttals to the state's motion in Limine. Number one, the state misrepresents what the defendant said at trial and produces no transcript, video, or other evidence to even make such a claim. However, barring their misrepresentations, the defense did attempt to call Tom Walker, hereinafter Walker, to the stand to inquire about his investigation and the fact he sustained 207 pieces of mishandled evidence in this case. Had the defense been allowed to question Mr. Walker about his report, the jury would have heard and the court would have learned that the report fails to make mention any of the evidence already known to be altered or destroyed. Since Mr. Walker was the investigator and is presumably aware of the evidence that has been tampered with, the defense had a right to question why these key pieces of evidence were not included in his report. The defense also had a right to know if he has any information about the extent of tampering, how many pieces of evidence have been altered or destroyed, and who was responsible. Mr. Walker's position in his investigation could potentially have given us some of those answers, or at least answers as to why the MCSO is refusing to investigate the evidence tampering that is known to have occurred. The defense could have also questioned Mr. Walker about the failure to collect and preserve evidence that would have been exculpatory to the defendant. Those failures, which could have exonerated the defendant, not only raised questions of reasonable doubt, but there is case law that states this infraction alone is a denial of due process. When identity is an issue at trial and the police permit the destruction of evidence that could eliminate the defendant as the perpetrator, such loss is material to the defense and is denial of due process. Quoting State versus Youngblood, Arizona 488 U.S. Unfortunately, the court erred in not allowing Mr. Walker to testify, which is yet another violation of Mr. Tucker's due process rights, an issue the defense will address further in our response. However, unless Mr. Ward can come up with a legitimate reason as to why the defendant's interview videos have been chopped up into nearly 80 different pieces with sections that are missing, then it is self-evident that videos have been altered, and these are not the only videos that were. The state became aware of who altered Rory Wilson's, hereinafter Wilson, interview video during his trial. The defense has inquired for years about the missing 3 minutes of video immediately after Mr. Wilson questioned, "If I say Ty done it, I get to go home." He testified at his trial that former MCSO Captain Penny Phelps, hereinafter Phelps, turned off the camera and then threatened to arrest his 8-month pregnant girlfriend if he didn't give her a story. So, guys, what I want you to understand here, that's been a question I've seen a lot in my comments, and that was what happened after that. Well, this is what happened. It was in his case. There's in the transcripts of Rory Wilson's case, Rory Wilson admits on the stand what happened. And he says, "She told me, if you don't give me a story, that I'm going to arrest your wife." And remember, his wife, his pregnant girlfriend was the one that had handled the trash bag full of dirty, bloody clothes. And she was trying to help him get rid of it. So she was going to charge her with us being accessory after the fact. That's what Phelps did. So that is a mystery that Mr. Tucker has finally been able to put out in the public. And this is why it's so important that these motions get read. And again, the judge probably will not grant what he's asking in this, because he's going to find a way out of it. Even if he felt there was reason to, he's going to put this back before a jury, most likely. We hope not, but most likely. But at least this is out here now. This is out here for someone like Vinnie Politan, Court TV, Law and Crime, somebody to see this case and see this stuff and start reporting on it on a national scale and use their resources to bring attention to it, who can't get shut down by YouTube censors. While it may not be obvious to Mr. Ward, the defense had long surmised that it was something along those lines. Did the state think it was just coincidence that when the camera is turned back on, Mr. Wilson suddenly gives Ms. Phelps a fictitious story about the defendant planning the robbery? A story that even MSCO lead detective Pitcher, hereinafter Pitcher, stated he knew was false at the time. If the state believed Mr. Wilson's story, then why were the fictitious co-conspirators never investigated or sought for questioning? The answer is because they knew he was lying, even though Mr. Ward knew or should have known that story was a lie. He still decided to prosecute this defendant based on nothing but lies. Given the lack of candor about the investigation and Mr. Ward's decision to prosecute originally, much less his decision to prosecute now, the defense questions if Mr. Ward or any other members of his office are even capable of the truth. We will reserve further testimony from Pitcher for the second half of our response, but it's important that his testimony not only affirms that digital evidence was tampered with, but lays the blame for that tampering with the state attorney in his office. So I hope you're understanding what we just read here and what's going to be provided in the exhibits, which have yet to be filed, but the court will be filed soon. Although I have this testimony already, don't have it ready to show you, but Pitcher testified in his deposition that he provided the codes for them to get into, for Phelps to get into, and Dunn essentially to get into the back end where they store all the electronic files. And after that happened, mysteriously, police statements disappeared, video from Tom Thumb disappeared, the exonerating video that could have exonerated Ty Tucker from behind CVS Pharmacy disappeared. All of this video disappears, and they claim it was an accident. But it occurs after she has access to get into the system that she shouldn't have had access to. She should have never had access to it. She had access to the entire system to get in without anyone knowing, because she could log in and make it disappear. And under the Sakalumi case, if the police have evidence, if they have evidence, video evidence, physical evidence, if they have evidence that could have potentially exonerated a defendant, and they lose it or it gets destroyed, then it doesn't necessarily mean you're going to be entitled to have the case dismissed, as there's other evidence, like, unfortunately, Mr. Johnson. But it does allow for the judge during trial to give a curative instruction that states that evidence should be considered by the jury as to have been evidence of his exoneration due to the fact that its existence is no longer here. In other words, they're going to get to assume whatever the defense was going to say was on that tape. The jury is instructed to say that was a tape that provided Ty Tucker an alibi, or that was a tape that showed that it wasn't Ty Tucker, because the police had it and they lost it. So this is extremely important here. Number two, the state again misrepresents the facts and blatantly lies, as the judge never asked the defendant to provide any proof that evidence had been tampered with, or we would have gladly presented him with our findings. No, the court again erred by declaring Mr. Walker's testimony irrelevant without even listening to the defendant's reason or giving the defense any opportunity to show such evidence. He simply denied the defense the ability to call that witness, among others. As for Tom Walker's list, the defense should have had no need to provide it to the state, considering they entered Mr. Walker's report into evidence just prior to trial. The defense should note, though, that Mr. Walker's report was not entered in by the state in its entirety, and there are pages missing, but since the state never introduced it at trial, the defense made no objections. Had the defense been allowed to call this witness, we would have also corrected their oversight, but as it stands, the state and Mr. Ward had the responsibility to ensure that they had a complete copy of the report prior to entering it. The defense is being kind when calling it an oversight, as Mr. Walker was working for the SAO when they entered his report, so they could have easily verified its completeness. The fact they entered it incomplete should just be seen as just more deception by the state, probably to avoid questions about the same list they now falsely claim was the responsibility of the defense to provide. Number three, the defense has already addressed this fabrication, as they didn't just obtain a copy of the list. Mr. Walker's report was entered in as supplemental discovery by the state. Furthermore, since the judge ruled that the defense could not call Mr. Walker, the defense had no responsibility to provide this list to the state. Number four, the defense has already addressed this issue. However, while Tom Walker's report doesn't specifically state that any of the 207 mishandled pieces of evidence were tampered with, had the defense been allowed to question Mr. Walker, we could almost guarantee the court that his answer to the question if any of that evidence had been tampered with would have been, I don't know. We could state this with such certainty because we know the scope of the investigation did not include Mr. Walker even attempting to ascertain if any of the evidence was altered, and only touched on brief explanations as to why they were mishandled in the first place. The answer, I don't know, that we expected may be good enough for Mr. Ward and the state, but is clearly not good enough for a defendant facing a life sentence. It's also false that evidence on that list doesn't pertain to the defendant in this case, as his buccal swabs are listed, as are some of his personal belongings, clothing from Matthew Bonnet, and plenty of audio and video recordings that were suspected to have been tainted by our investigation and were used against this defendant at trial. Number 5, the defense has already addressed this misrepresentation, as the state is either ignorant to the facts of the case they are prosecuting or they are just bold-faced lying. The defense will be happy to provide the state with a list of evidence that is known or suspected to have been tampered with or destroyed, but as previously stated, hold on one second, guys, I apologize. Give me a moment here. All right, guys, sorry about that. I had my kids arrive here from practice. So anyways, my dog went off. But anyways, let's see where we were at here. We'll just start at the top here. The defense has already addressed this misrepresentation, as the state is either ignorant to the facts of the case they are prosecuting or they are just bold-faced lying. The defense will be happy to provide the state with a list of evidence that is known or suspected to have been tampered with or destroyed, but as previously stated, much of it is self-evident. That while the defense is willing to create and provide such a list, it is extremely frustrating and infuriating to think that after 6 years of pretrial discovery, where these issues were repeatedly brought before the court and to the attention of the state, that the defense would now be required to educate Mr. Ward and the state on the nature of its own evidence. Evidence that Mr. Ward has used to maliciously pursue prosecution against the defendant when he should have known the facts before ever even filing the information or seeking an indictment. The truth is, he does know, and he knows the facts don't support and never did support his decision to prosecute the defendant. The defense has run out of patience dealing with the lies and fabrications that have been put forth by the state through the entirety of this case. It's not only offensive to the defendant, but it's a mockery of justice, and the fact that Mr. Ward is even suggesting that evidence wasn't tampered with only shows the extreme level of dishonesty and self-interest in this man and in the prosecution of this case, considering almost all of the tainted evidence leads right back to the SAO. While this is unnumbered, the defense wanted to make the court aware that the state motions currently being considered were never sent to the defense. The defense only became aware of the filings because we regularly checked the docket posted online by the clerk's office. The defense again feels this wasn't an error because their filings all attempt to hold the defense to a 10-day response time they're assuming the court will grant while filing a significant amount of requests all at once. We are aware no rules prevent the court from ordering a 10-day time limit or prevent them from filing the request as stated, but there are rules about sending copies of filings to the defense at the time of filing. The state has been in possession of the defendant's email address for a long time now and has sent previous filings to that address. So we would request that if the court decides to allow the case to continue, could it please remind the state of its obligations to send copies of any future filings to the defense. All right, guys, so now we're going to get into the defense's position on tampered evidence, the investigation, misconduct, and the continued dishonesty of the state attorney and SAO. So quite some big statements here. I'm actually very happy to see Mr. Tucker going forward with this, putting it before the judge. Again, it may not result in a ruling to dismiss the case, but it certainly is going to bring the judge in line, to bring attention to this judge, what's going on in this case. So the continued dishonesty, let's go in here. So number 1 says, the Fifth Amendment's due process clause states that no person shall be deprived of life, liberty, or property without due process of law. The 14th Amendment also provides due process protection from state action by declaring that, No state shall deprive any person of life, liberty, or property without due process of law. Similarly, Article 1, Section 9 of the Florida Constitution provides that no person shall be deprived of life, liberty, or property without due process of law. 2. The fundamental requirement of due process of law is the opportunity to be heard. 3. The opportunity must be full, fair, and not illusory. It is a denial of due process when a party is not afforded a chance to fully present his or her case, including defenses. 4. The defendant's due process rights were violated when the court deprived him of the opportunity to be fully heard in the presentation of his defense, his witnesses, and evidence. Specifically, the court made significant errors by forbidding the defendant to inquire about the quality of the investigation and the tremendous amount of misconduct that has been committed in this case by members of MCSO, the SAO, and by the judiciary. The court also erred when it did not allow Seth LeVay to authenticate the motion to suppress filed by Mr. LeVay on behalf of John Travis Johnson, hereinafter known as Johnson, as it was a public document and not subject to attorney-client privilege and could be used, unlike the state suggested and court ordered, to refute the statements made by Mr. Johnson with his previous inconsistent statements in that motion under the Federal Rules of Evidence 801, exclusions to hearsay. 5. The fundamental principle of due process of law demands notice and an opportunity to be heard before a final judgment is entered. 6. The state and Jones made broad and sweeping assumptions concerning the relevance of testimony, lines of questioning, and evidence to be submitted by mistakenly declaring the investigation was irrelevant, just as the state again attempts in this motion, Exhibits A and B. 7. The defense has used quotations around its words such as errors and mistakenly because the defense truly believes these miscarriages of justice were not the products of negligence, but much like the state's current motion and notices, they were calculated attempts to silence the defendant, the only purpose of which, and purpose in this prosecution, is their attempt to conceal the nature and magnitude of their own misdeeds. 8. A criminal defendant has a Sixth Amendment right to present his own witnesses to establish a defense. 9. The defendant was denied the ability to call witnesses such as Mr. Walker to establish his defense based on the same misperception of relevancy and assumptions about the line of questioning. More importantly, the defense believes it wasn't allowed to call these witnesses because they would also show the MCSO and state had attempted to manufacture evidence in this case. We also believe that eliminated witnesses would have bolstered the testimony already provided by former Detective Pitcher. Testimony that would indicate that members or former members of the SAO may actually be responsible for evidence tampering that did occur in this case. Big statement there. Big statement there. And what he's referring to, again, if you go back, what we were talking about earlier and what I've referenced on this channel, he's talking about the destruction of tapes, the destruction of the Tom Thumb tape, the destruction of the CVS tapes, the destruction of the original police statements that ended up chopped up and the original's not in there, which again is relevant because it wasn't able to be entered due to the fact that it wasn't complete. And then they attempted to take advantage of the fact that the statement was inadmissible due to its incompleteness. They attempted to then take advantage of the fact that it hadn't been able to be admitted as a whole. It could only be admitted for impeachment purposes, sections of it that would have existed. But it was not able to be admitted as a whole body, which meant that the state then argued to the court or to the jury that Tyrone Tucker had no other way to know there was blood of the victim on the knife other than being there at the scene, which was not true. And while the jury could say, well, maybe that's what they think, but they also deserve to know that he was told this information by Captain Penny Phelps, that it was not some, huge smoking gun like Mansfield and Alvarez tried to stand before the jury. It's the one thing that absolutely enraged Vinnie Politan, because it's truly just a prime example of the nature of the corruption and the way they've tried to railroad this guy into prison when he is factually innocent. Anyways, let's get back to reading here. 10. As far as the relevancy of the investigation and the misconduct, it is clearly established that both are relevant to any criminal proceeding and that the government must be able to make make its claims based on evidence that has been fabricated or manufactured, altered, or tampered with, misrepresented, and only under limited circumstances is it allowed to use evidence that was obtained illegally. Without being able to inquire about the investigation or to sustain misconduct in this case, it would be impossible to show the truth behind the government's actions, and furthermore, it allows the state to claim anything as evidence without any means to verify the validity of the evidence they are presenting. This is neither consistent with due process or the truth-seeking functions of trial. 11. As of 1959 or earlier, it was well established that a defendant had a due process right to be free from false or fabricated evidence that results in his conviction. Those charged with upholding the law are prohibited from deliberately fabricating evidence. Zahiri, defining a constitutional right not to be deprived of liberty as a result of the fabrication of evidence by a government officer. 12. A conviction obtained through use of false evidence, known to be such by representatives of the state, must fall under the 14th Amendment. 13th, the state is very aware that there was significant tampering done with the digital evidence in this case, which goes above and beyond Mr. Walker's sustained mishandling of approximately 207 pieces of evidence documented in his AI report or IA report. 14. As was previously stated, many of the videos that were tampered with are self-evident, such as the defendant's interviews done with the MCSO detectives that were edited into approximately 80 different pieces with portions missing. This should never happen. However, the state neglected to mention that Mr. Walker's report also stated that many videos were missing from the case file at the MCSO, which means they were not entered into evidence or they were deleted. But either way, it breaks the chain of custody that these videos had to be recovered from the state attorney's office. Some of these videos were used at trial. The defense is yet to file a motion to exclude this evidence because we believe some of it to be exculpatory in nature, and other exculpatory evidence has either disappeared or was not collected at all. In the latter situation, we believe it was done completely in bad faith by investigators, as more evidence, such as forensic evidence that could have been found or not found, could have been exculpatory to the defendant by proving he was never in the vehicle alleged to be used in the crime. The MCSO failed to impound the vehicle and only searched it for physical evidence prior to its disappearance, thus negating the chance for the defense to inspect the evidence. The defense has never heard of another homicide case where a vehicle was used, but the defendant failed to do forensic search or impound and secure the vehicle for evidence. Now, again, guys, understand this. Under the Osaka Limine case, that vehicle could potentially be considered evidence that was destroyed, or it's destroyed now. They released it without investigating it. So the idea here is that Mr. Tucker would have said if only one man got back in that car and he was in the driver's side of that car, and there was no other evidence indicating, and there could have been blood evidence indicating that that man was at the scene and he wasn't just driving up and dropping them off, and the police failed to secure it, investigate it, and take it into custody. That's it. Then Ty Tucker would be entitled to a instruction that any evidence should be assumed to have been exculpatory to Ty Tucker. In other words, it would be evidence proving his innocence. It would have been evidence proving that John Travis Johnson was the driver of that truck, that he got in that truck, that there was blood evidence found in that truck, and that's what the jury should assume. That's huge. And when you're looking in the totality of the case, that you've got a jury who's going to assume he had an alibi, that the police destroyed the alibi evidence. They destroyed the evidence that would have disproved whether John Travis Johnson was or wasn't the killer in this case. And they're destroying that evidence. Then you've got that's earth-shattering evidence. That is huge. That is huge. So let's continue reading here. 15. The defense will not rehash the state's knowledge of Wilson's testimony at trial, except to add that Wilson recanted his statements about the defendant during his testimony. Yet, the prosecution still allowed their witness, former Detective Danielle Malone, to perjure herself on the witness stand by saying Mr. Wilson's statements, combined with Mr. Johnson's, are what made the defendant a suspect. The state knows that testimony was false because of the so-called hot mic tapes that recorded exactly when and how Mr. Tucker became a suspect. It's also important to note that John Travis Johnson also recanted his statements about Mr. Tucker prior to the state cutting him a deal with but the prosecution in Jones improperly kept his motion to suppress out as impeachment evidence. Jones didn't allow it because it's the only evidence the state had, which is another issue we will address in our forthcoming motion to dismiss, as it amounts to subornation to perjury. This federal crime goes beyond the loss of license by the bar and can result in a prison sentence of up to 5 years. If Mr. Mansfeld and Mr. Alvarez were charged by the state for witness tampering under FS 914.22, the penalty could be increased to life imprisonment due to it being conducted on a capital case. 16. It is important to note that some of these pieces of evidence, unlike the state's claims, such as the video from Tom Thumb or the missing sections of the Florida Keys video, and even the defendant's own statements, were material and exculpatory to the defendant. Now, I want you to understand, guys, what he just referenced here, and this is something I wondered myself. Remember, give me one moment. Now, this is something I even wondered myself, because we see John Travis Johnson and we see Rory Wilson walking in that tape, but where is the tape? Where is the evidence that would show John Travis Johnson driving back? Maybe we could have seen whether there was one person or two people. We could have seen the exact time he was driving back. We could have seen a lot of different things. Where's the tape showing them arriving and going, which could have possibly shown that there were three people in that car? Guess what? It's all destroyed. And when did it get destroyed? After Pitcher gave Penny Phelps access to those videos. Those are exculpatory videos that could prove the innocence of Tyrone Tucker, and they were destroyed. As a result, he is at least, at a very bare minimum, entitled to an Osakalumi charge. And we're going to get into what he's going to ask the judge to do. I figured the judge will wiggle his way out of it. But why? Under the due process clause of the Constitution, and when your due process rights have been violated to the extent that they have in this case, to the extent that they have fractured the ability for this case to be tried fairly in front of a jury, the tapes are destroyed, tampered with. Witnesses have been tampered with. Witnesses were fed evidence. Police statements were destroyed. The state attorney in the last case was lying to the jury and using the fruits of that destruction to try to use that as a smoking gun against this man. There's been no clear case. There is no clear case. It's being argued by Tyrone Tucker, a non-lawyer, who's doing a great job on this motion, by the way. But there's no clear case right now that could be out there that would show you or demonstrate to you that this is a case that should absolutely be dismissed and be gone and be dismissed with prejudice, and it should never be able to be filed again. It's broken. And again, this is why Tucker is confident in his own way that he thinks, hey, we're going to be able to get this case dismissed. I don't know. It's crazy. So anyways, let's keep reading. It's no mystery as to why the state would request that testimony about tainted evidence not be presented to the jury, considering in his deposition, when Pitcher, the lead detective, was asked about missing and altered videos, he testified that he gave unrestricted access to the raw digital evidence to former ASA Colleen Dunn, hereinafter Dunn. So it was Dunn, not Phelps. I apologize. I thought it was Dunn, because the state attorney should not have had access to that evidence. Colleen Dunn, the disbarred attorney who's lied to several courts, had unrestricted access to videos which went missing after she gains that access. Think about that for a minute. The Florida Keys Electric that would have shown the video or the truck going, returning, that evidence is destroyed. CVS footage, destroyed. Tom Thumb footage that would have shown that Ty Tucker had an alibi and confirmed his alibi, destroyed. Police statements that showed that her friend, Penny Phelps, was feeding the stories to the witnesses. Those get destroyed, chopped up into 80 different pieces. Evidence that she was utilizing the read technique on these witnesses, which is something that, again, I've shown you, and I'm sure that Mr. Tucker, I'm told by him that he's going to be getting into this in his motion. It demonstrated that, or he has an expert that demonstrates the read technique is fraught with examples of false confessions. false, there's huge history of it. And he analyzed this and said, yes, this is a custom-made case where the Reed technique was used, and it appears that she elicited false confessions out of John Travis Johnson, Rory Wilson, and his girlfriend, April Walker. I mean, this is crazy. He also testified the SAO had direct access to the body camera footage on a different system. Chain of custody exists to help prevent tampering, and especially allegations of tampering by the prosecution. Unfortunately, Dunn seems to be a product of Ward, since she specifically requested this access from Pitcher and was suspended from the bar for lack of candor in this case. It's also important to note that she was suspended just prior to that for dishonesty to the court and withholding evidence in another case. The defendant's wife also had a case pending before the bar that would have seen Ms. Dunn lose her license permanently for further misconduct in this case, but the case was closed due to improper comments from Jones. She will be refiling those charges, and we will be filing additional complaints against Mr. Manfield, Mr. Alvarez, and Mr. Ward after the completion of this case, along with the Judicial Qualifications Commission complaint against Jones. Now, I want you to understand the other factor here. Word on the street is Dennis Ward has rehired her. Why would you rehire her if you have a dishonest, disbarred ASA? There's one reason. Because he sent her to do his doing, to do the misdeeds, to delete the evidence, to cover this thing up. Because remember, at one point there was an election coming up in 2020 when they were dealing with this case. They needed this case to be handled. They hid the important assets in this case that they needed to help, that they couldn't have exposed. And now we're in an election year. And what do we see Mr. Mansfield doing? Mr. Mansfield's trying to get this case tried in August. Why? Because he doesn't want it to collide with the election schedule of Mr. Ward. But we'll see if it happens. Pitcher also testified concerning this unrestricted access that he didn't think it would allow her to edit or delete files, but that he would need to check with their IT department. The defense believes Pitcher thought to be wrong, as even the word unrestricted would denote all access. And the very nature of Pitcher's job would require that he be able to add or remove files from the main case file. In other words, they could remove, they could add, they could alter. 19. The defense also presented a text message to Pitcher during his deposition that came from Dunn, asking Pitcher to remove the restrictions on the files, and this message made clear this access was being utilized by other individuals at the state attorney's office. Pitcher verified the contents of this message, the nature of it, and that he ultimately gave them access. This is why Mr. Pitcher needs to be called to the stand in front of the jury. And this is what, if this case makes it back to the jury, one of the ways this judge is going to get out of this is saying, unfortunately, procedure wasn't necessarily followed because of Mr. Tucker's inexperience with how to do these things on the fly, but it wasn't necessarily followed on how to get these things in. In other words, they didn't have Pitcher there. They didn't have Phelps there. They didn't have Dunn there. I mean, we need to make sure these people are coming in, along with O'Quinn, that they can come in and testify about these things. But the problem is that, it's not really a problem because, when you're looking at the way this case is and the fact that at the end of the day, there's no evidence. There's no evidence in any way, shape, or form when you get to the end of the day. I mean, that's it. 20. While it is alarming enough that Dunn and others at the state attorney's office gained access to the raw digital evidence in this case, especially evidence where we know files were edited and deleted, it's even more alarming that he testified that by giving her unrestricted access, it wasn't only good for the Treehouse case, it was good for every case in Monroe County. So I want you to think about that. All these cases, the cases she was involved in, the cases there was another case that she got disbarred under, that she was doing similar actions and activities. In this case, they went and gave her access to where she could affect any case. She could go in and delete files, make files disappear, and they could come up with any ready excuse. That is scary. They have a file in there. They have something. This is a scary, scary thought. This is the equivalent. If you've seen on Netflix, they had the octopus case on there. It's a documentary on there where they were talking about Promise software. What was Promise software? It was a backdoor into the software that it could change things and change files. And it's scary when they can do that. And it was brought in for case management and it got misused. This is a prime example of them using that and what can be done when we don't know that that's what happened. And we don't understand that something got changed or altered. Something could be deleted and added back in. Something could be taken out. I mean, listen, and these people want to cover up their own misdeeds, their own bad actions. We saw a cop earlier today that we were watching who, this is a patrol officer's who, for a DUI case, is pouring out liquor to make it look like this gentleman had an open container in his car that he mixed a drink with, just to try to bolster a DUI case. That's a DUI case. What do you think they're doing here for an unaliving case, a murder case? What do you think they're doing here? They're willing to do anything. These people are willing to do anything because they got bigger and greater assets. There's a lot of money flowing down there. And that's what was going on in this case in the background. 21, Christine Poist was the assistant state attorney at that deposition. She has since moved on to the public defender's office. But if the defense were to issue a subpoena to Mrs. Poist, we highly doubt she would testify that she failed to tell Mr. Ward about Pitcher's testimony, especially since immediately following that deposition is when the state sought a gag order against the defendant and his wife. Thank you. And that's part of what we're going to be talking about in Gagged, why they silenced Tyrone Tucker. Mr. Ward may have forgotten Pitcher's testimony, but the defense has not, or other illegal things that Pitcher swore under oath were done by members of the state attorney's office in the prosecution of this case. Exhibit T. This is why we need to ensure. This is what they're scared of. Ty's got to get these exhibits up because they are dead scared. You heard it in the hearing earlier. You heard it was either Alvarez or Ward. Somebody saying, do we want to address the gag order? Because they want that gag order up, because that gag order doesn't just stop them from talking. It stops anyone from seeing the documents, the depositions, the statements, all of it. It is blocked from public view for 90 days, and then a judge has to unlock it. To date, there's been no supplemental. Oh, really, Gabrielle? I just heard this. Okay, that's awesome. Well, I look forward to seeing it. Is that going to be on their channel? I can't wait to see that. To date, there has been no supplemental from the SAO about any results from any investigations into this serious breach in a chain of custody and the possible county-wide tampering with evidence by their ASAs. But considering the MCSO is refusing to investigate this breach or the digital evidence that was tampered with, the defense would have to assume that the county-wide implications are extensive. As was previously stated, the MCSO never answered the question in Mr. Walker's investigation about the missing and edited videos. So to date, we have no idea how much or what of the digital evidence in this case was tampered with, but we do know some of it was, and due to Pitcher's testimony. And now, Mr. Ward's complete denial of its existence. The state attorneys would be prime suspects for the who and the how. This would mean it was sanctioned knowingly by Mr. Ward. On October 25th, 2023, the defense sent an email to Captain Lee Ann Holleroyd, who is head of Internal Affairs Department at the MCSO. In that email, we asked that their cases from the Treehouse investigation be updated to reflect current information, that the Internal Affairs investigation be reopened in order to resolve the criminal charges associated with that incident, and that IA give us an answer to who, when, and what files from the digital evidence in this case were altered. The defense also pointed out that it should be relatively easy to answer be a relatively easy question to answer for their IT department. However, we received an email from Captain Holleroyd on November 2nd, 2023, stating that these cases are closed and no further investigation will be conducted. So, all right, so see here, Gabriel, you said Ty said he will announce it when it's going to happen. Lauren said she's trying to get a Ty. I think I came in late. I think he was talking about this on Friday. Now that kind of adds context. I didn't go back and rewatch. I should have. But awesome. That's great news, man. I cannot wait. I will be watching that. That will be amazing. And we will be making sure that gets plenty of airtime here. 24. In an abundance of caution and prior to filing a complaint with the Florida Department of Law Enforcement, the defense sent an email to Lieutenant Colonel Sibilia, who is the direct supervisor of Captain Holroyd, on February 21st, 2024, asking him to verify that the MCSO is refusing to investigate the crimes committed in both IA investigations, from 2019, and the destruction and or tampering with evidence in this case, and potentially the many other cases in Monroe County. It is significant to mention that Lieutenant Colonel Sibilia was also another witness that Jones refused to allow to testify at trial. That email is yet to be responded to by the Lieutenant Colonel. 25. The defense will be filing a complaint with the Florida Department of Law Enforcement and adding it to the complaint already accepted by the Department of Justice. But given how crucial the information is to this case and to Monroe County as a whole, the defense has decided not to wait for other investigations, especially when this defendant has been waiting almost 7 years at the risk of his life for answers to these questions. So the defense is also going to request the clerk issue subpoenas to the IT departments at both the SAO and the MCSO for their logs on who assessed the main case files, when it was done, and what was done with the files while they had access. To be clear, we are not attempting to gain access to any work product that the state attorney's office may have stored in their systems, but we do want the logs showing the aforementioned information, and it is well within the scope of information the state attorney would be required to turn over as possibly exculpatory evidence under Brady. 26. Before concluding, the defense wants to make the court aware that when Ward makes claims of the defense trying to prejudice the jury by truthfully mentioning tainted evidence, that it wasn't the defendant who got caught lying to the jury about the evidence in this case. The bias Jones had against the defendant weighed heavily in his decision making throughout the entire case, but no more so than allowing the jury to deliberate and make their decisions based on proven lies told by the state. Even with those lies, the jury still came back hung, and now the state comes back to court with more lies, asking to silence the defendant about the truth again. The trial was an embarrassment that harmed the public perception of the justice system in Monroe County, but the defense would like the court to consider how continuing to allow this dishonest prosecution makes any sense towards repairing the damage already caused by corrupt officials. How does allowing any more misconduct, even if they could convict, bring integrity back if they have to lie to win? Then there's also the other cases in the county to consider. What happens to the other cases where the SAO used that access? Because if it allowed access to all of the cases and it was used by more than one person, then it stands to reason that they did it in other cases, convicting people with altered evidence. The defense will submit our motion to dismiss after we have transcripts from the trial, but it's just more piled on what they've already shown the court with this motion. So the defense would ask the court to please use its discretion in the interest of justice, in the best interest of the county, and in ending an almost 7-year ordeal for an innocent man. If the court finds it cannot, please offer some relief that ensures this defendant will at least get a fair trial. Wherefore the defendant, Franklin Tyrone Tucker, respectfully. So he's asking, all right, so let's get caught up here. Gabriel says, me too, it's definitely going to be amazing. Tyler Clear is a key witness, said numerous times. Yes, he was. But not only that, but they also need to get him hammered in about the fact that he originally said he saw the individual get in a truck and get out of there. That is huge. And if his memory gets refreshed, he's allowed to bring that in. And they can, and again, that's the most, recent statement. So that should be, given more credibility than statements made years after or months after or days after. The judge said, yes, we covered that earlier, actually, Gabriel, but yes, trial date is September 5th, but it could get moved back, and it depends on how they were doing it, on how they will do it. Yes, actually, you probably came in a little late. We actually watched that entire hearing earlier, so if you haven't seen that hearing yet, you can go back. You may have seen it on, I think Ty was on Excited Utterance watching it as well, so you may have already seen it. It may already have been something you've seen. You may not need to go back and watch it. But it is difficult to watch because you don't get to hear Ty's responses, so that's a little difficult sometimes to watch. But talking about this motion and what this means. Sorry, I tried to do a background switch and didn't realize I had that set up when I had to take the break earlier to let my kids in. But anyways, talking about what this motion means in terms of what he's asking them to do. What he's asking them to do is essentially, and I don't know that, I don't know that the judge is going to do that without he's going to have to file the motion to dismiss. I don't know that the judge is going to come in, but what he was hoping and asking him to do is saying, listen, my due process rights have been so badly damaged in this case. The evidence has been tampered with. There's no solid evidence that hasn't been touched. John Travis Johnson, this is a guy who was fed his story on tape by Penny Phelps. That interrogation was destroyed and then reemerged in pieces. Okay. Same with Roy Wilson. Same with Tyrone Tucker's. And this is after Colleen Dunn gets access to all the videos. You have potentially exculpatory evidence, the Tom Thumb case, the Keys Electric tape. That's exculpatory evidence, destroyed, missing. So none of it should be allowed. That evidence showing John Travis Johnson shouldn't be allowed. And one of the things I would say that Ty's got to do here is he's got to file motions to suppress. He's got to suppress out the evidence. And then you could file the motion to dismiss. You've got to get rulings that this evidence, with a new judge to consider these things. These are valid ways, but this is the problem. And this is the way they wiggle out of it. And if you saw, we haven't gone deep into the Calvin Riley case. That's the last name I was escaping me. But in the Calvin Riley case, when they get to court, the judge finds a way to squeak his way out of it. You've got to follow the procedures. So this is a great motion to get this information out. It's a great motion to kind of crash course the judge on what you're going to be doing. Will the judge dismiss this case? No. But it's needed information, because the real thing here is that, or the real goal here is to prevent the state from achieving what they were trying to do with their motion in Limine, which is they were trying to prevent Ty Tucker from bringing up any of this IA investigation, and essentially trying to toxify the water, so to speak, by making him think, Ty Tucker's out here, alleging there was evidence tampered with and stuff. No, there is evidence that's missing. There's an IA report. These are things that were legitimate stuff. They're lying. They're trying to, again, turn this judge against Ty Tucker, but I don't think that's going to work. I think this judge seems to be fair. Now, he's going to demand that things be procedurally done correctly, and he's not going to necessarily just go, well, I'm going to just overlook a procedural error. No. But there is a way to do this, and one of it is they need to attack all the evidence. They need to get the videos thrown out. They need to get the Keys Electric thrown out, whether it's exculpatory or not, throw the entire evidence out. Because the reality is it's not on Ty to prove his innocence. It's on the state to prove his guilt. If you don't have any piece of the Keys Electric tape, that's gone. If you don't have the Marina tape, because it's been destroyed, and you can't verify in the fact that it was taken and it's missing, and you don't have a chain of custody, that can't be used now. Okay? These are simple things that should be done and filed. I don't know why his original attorneys didn't do that. Because once you eliminate all that, and then you say, well, wait a minute, the only witness we have is a witness who filed a motion to suppress that is going to contradict what he says happened. And he says in that motion to dismiss, Seth LeVay says, I filed it in good faith because I believed it, and I filed it on the basis that I believed it to be true at the time it was filed. And I believe Travis was being honest with me at the time it was filed. Well, that's something that if that's all you have to put before the jury, is that going to get you to a jury? I don't think it would. And then on top of that, when you just look at the entirety of the case, the only witness they can put forth has been essentially tampered with in a sense. He was fed this by a corrupt police captain who lost her job, who tampered with evidence. The due process clause clearly states, as Ty laid out in here, you can't, the remedy for this is dismissal, because you cannot factually refute tampered evidence that's been tampered with. It's impossible. The state Supreme Court says you can't. So as a result, he's entitled to this. So he's going to have to file the motion to dismiss. He's going to have to file the motion. He needs to file motions to suppress all the evidence that's incomplete. And at a very minimum, and then also file and try to attempt to get an Osakalumi instruction and ask the judge that if this case is going to go forward, then any evidence that they had in their possession and that got destroyed or lost, there's an instruction that states we are to assume that that is evidence of his innocence. You do that, this case will be gone. Bye-bye. And we'll see if this judge is a fair guy. We hope he is. We really hope he is. I hope he is. I hope this case doesn't get back to trial. But it seems like, judging from what I've seen down in Florida, I don't think that's avoidable. I don't think we're going to avoid a trial necessarily unless they could get all the evidence suppressed and show, maybe then. But it's got to be done procedurally correct. And that's why, his attorneys, we would think his attorneys, allegedly these high-priced attorneys that have been paid a lot of money, but I can tell you, many attorneys, many times, my dad has come in and there was a lot of high-priced attorneys that got paid, and my dad came in and helped people out and got appeals reversed and had them file habeas. And this was long after he was practicing. This is when he wasn't allowed to practice anymore. And he was helping these people file things on their own, their family file things on their own, hooking them up with attorneys to help them file these procedure things that were above their pay bill, and getting cases reversed, murder cases, SA cases. So just because you're paying someone big money, don't believe that you're getting necessarily somebody who is the best at that moment, or that they're giving you or that they're looking at all avenues of success. Because it takes a lot of work. It takes a lot of time. And sometimes, some attorneys, they just don't think of these things. But great motion here. I'm glad that this got before the judge. We'll see what it does. Let's see what's going on in the comments here. Yep. Yeah, gotcha. Yeah, I need to go over and watch Excited Utterance because I know he fills in the gaps over there. I have not watched that, but yep. But yeah. So that's where we're going to leave it, guys. I wanted to come in. I wanted to go over this motion. When he files that motion to dismiss, which sounds like from this hearing today, they're not going to be providing him the transcripts. They're going to provide him with tapes. I don't see Ty's got to file that motion before he worries about getting transcripts, because it'll take a long time to get these transcripts that he wants. And then you got to go through it, and then you got to include it. He's just going to have to file the motion. And again, just like the state did in this motion in Limine, they filed the motion. And you know what? Maybe the judge will stop everything and say, we need transcripts. But file the motion, show them what it is. If they're going to contest any aspect of the trial or what the transcript said, again, there's apparently official recordings. They can go back and listen to those official recordings. I believe they're audio recordings. They are not visual recordings. And that's what they're going to be able to rely upon. So Ty can make assertions that this is here and this is there, and the judge will be able to go back and listen to those audio recordings if he needs to, or order a transcript for the portion that's contested. So anyways, guys, I'm gonna leave it there, guys. This is the ways to support the channel. Putting it up here. YouTube has decided to attack the channel and try to take us down. And they've come after us. But we're up still, but we're not monetized in any way. And they've also taken away the ability to do any memberships or any things like that. So we've linked up with Buy Me a Coffee and coffee.com. I explained this earlier in Justice Watch Live, but it's not just a place you can show financial support. It's also a place that we're going to be posting news, schedules, updates, when we're going live, what our plans are, information and updates about cases. So even if, go over, get yourself affiliated, get registered with it. So that way, if something happens to this channel, you know where you can go and find out what's happening. So you can get registered as just a free follower. And then, of course, like I said, there's membership opportunities and stuff like that you can do. But yeah, unfortunately, they came after us. And we've got about another 90 days or so before we can figure out where we're going to stand. But they could come after us and take us down at any time. So it's just, when you're covering cases and covering controversies and you're covering controversial people are going to come after your channel. They're going to file things. They're going to do things. And you know what? You're going to have to fight it. And we unfortunately lost the monetization aspect, but they are allowing us to at least air and broadcast on probation. But you know what? We're going to keep covering the cases. We're going to keep doing what we need to do to get this stuff out in the cases we're following and covering. So no, I don't think it's any coincidence that we're covering the Nikolai Mew case. And again, remember, Prosecutor Mansfield showed up in my comments when I was covering this case a long time ago. So he believes this channel was put up by Ty Tucker. I didn't know Ty Tucker until his case came on Court TV. But I wouldn't mind knowing Ty Tucker. I think Ty Tucker's a great dude from what I've got to know him by, and we've talked and communicated. And he seems like a good dude who's found himself in a very tough situation. So I'm not intimidated by that. I don't care. It's fine. So it is what it is. But we're gonna keep plowing along. So anyways, these are the modes. There are the links in the description. Click on them. I haven't decided which one we're going to make the official, whether it's Buy Me a Coffee or Ko-fi.com. Whichever one gets the most followers or gets the most people that are coming in, I'll probably stick with that, or I might stick with both of them. We're also going to try to build up a Patreon page as well, so we can put things up there as well, and do things there. And then we are now live on Rumble. I would encourage everyone to go over to Rumble, get affiliated, get an account, and follow the channel. They allow immediate monetization. It's really awesome. Anytime you watch over there, you're supporting the channel. We're monetized fully over there. I didn't realize that's how it worked, but it's pretty neat. You can also become a member today. You can send a rant today, which is like a super chat. Really cool platform so far that I've seen. Don't necessarily agree with all of the content on there, but I don't have to. But it's a great place. It seems like a pretty open place. We're live on there right now. We're live on Twitch. We're live on Kick. We're live on Twitter. So check us out on all of those. And we're live on YouTube as we speak right now, where we have a subscriber base of 20,000, which has grown in a crazy, incredible way. Can't believe how fast it's grown. So I appreciate all the supporters and subscribers. So if you have Rumble or you don't know what Rumble is, look it up, download the app, get over there, and get us over there. And if we can build a following on Rumble, it won't even matter what YouTube does, because they won't be able to shut us down or silence us. So that's what we want. Anyways, guys, I'm going to call it here. I ended up doing this and missing dinner, so my wife's going to have a word with me, I'm sure, when I get done with this, because I decided to go live because I wanted to get this out there. I didn't want this to get on the back burner. Be on the lookout. I'm finishing and trying to finish the next episode of Gagged. So important. It's going to become number one now, I think, because I've got to get this out there after what I heard today in that video when it says, do you want to deal with the gag order? Because we need to get the full story of that first gag order out and get it done. Yes, you too, Gabriel. Thank you very much. I appreciate everybody else that's watching, everybody that's watching on all the platforms. Thank you very much, and we will be talking soon. Until then, guys, let justice prevail, and I will talk to you soon.